Good afternoon, everyone. This is a meeting of the Right to Know Advisory Committee's Public Records Exception Subcommittee. My name is Chris Parr. I represent law enforcement interests on the subcommittee and the full committee as well. And I'm going to have everyone go ahead as a first item on the agenda, and everyone on the committee, subcommittee rather, and everyone from OPLA staff introduce themselves and pass it off to the next person. And I'm going to start with the who I think are the most important people on the call, the OPLA staff. And Peggy, why don't you go ahead first? And
thank you, Chris. I'm Peggy Reich. I will work in the Office of Policy and Legal Analysis. Colleen.
all right.
Sure. I'm Colleen McCarthy-Reed. I'm also in the Office of Policy and Legal Analysis. Rachel.
I'm Rachel Olson, and I am in the same office.
Excellent. And I'm going to start with now subcommittee members introducing themselves before we go to our honored guests. And why don't we start with Linda?
I'm Linda Clancy, and I represent the Maine press. Sorry, you want me to I'll hand it to Julie.
Okay.
Thanks, Linda. I'm Julie Finn, and I represent the Maine Judicial Branch, and I will hand it to Kevin.
I am Kevin Martin. I represent state government interests. I'll pass it off to Eric.
I'm Eric Stout, the member with background in information technology, and it's my honor to pass it to Judy Meyer.
Thank you. I'm actually not a member of this subcommittee, but I'm a member of the larger Right to Know committee, and I represent Maine's newspaper publishers on that committee.
Great. And I'm going to kind of just myself introduce our other two guests. I'll start with Justin, if you could just introduce who you are.
Good afternoon. I'm Justin Andrus. I am the Executive Director at the Maine Commission on Indigent Legal Services. And in that capacity, I represent every Mainer.
Excellent. And Kate?
Hi, and I'm Kate McBrien. I'm the Maine State Archivist. I just kind of attend these meetings every once in a while so I can add support when I can.
Plus, they're just so interesting, right? So, okay, it looks like another subcommittee member just joined us, and I will have John introduce himself.
Hi, everyone. I'm John Bolton. I'm an Assistant Attorney General, and I represent the Attorney General.
All right, excellent. Thank you very much. So item number 1 on the agenda is done. And we're going to go right to item number 2, which is, thought I got this up, but bear with me. Let's see. That can't be the right agenda. So I know that the right agenda item is supposed to be speaking about the reason why we have our guests, Justin and Judy here. And it's to discuss a public records exception that we're taking it out of order. It's from Title 4. And I'm going to, I know that we received some responses to the questionnaire that we usually have agencies complete when we have to review the different exceptions under the law. I've had a chance to look through that. I hope everyone else has had a chance to do so too. And I think what I'll do is, I'll open the floor up to any subcommittee members who have questions for Mr. Andrus about the responses to that questionnaire. Anyone? Did everyone see the question? Oh, I'm sorry, Eric, go ahead.
Yeah, I had 2 basic questions, and I did read that subparagraph as well as all of the, I think it's 1806, all of the various sections, and I see that it mentions about costs 5 or 6 times in the larger sections, responsibilities of the commission and of the staff. And so there is a concern about managing the costs, because there's, it's about funding the indigent legal services. But my two questions are, is there a time for confidentiality that changes like after the case is closed? Certainly there's a need to protect the defensibility and the confidentiality while the case is in process, but some confidentiality in other contexts changes when the case is closed. So that's my first question. My second question is, if there's an interest in more transparency of costs being administered through the commission for different defendants, is there an opportunity to de-identify those costs? In other words, to find out like what is the average cost or the highest cost without identifying the individual and violating any confidentiality or defensibility to the individual case. So those are my two questions. Does the time of confidentiality change when the case is closed, or should it if it's not specified? And second, what about public interest in costs being expended, and can there be more transparency that doesn't identify the individual? Those are the two basic questions that I have.
So I will address
And
both of
apologies.
those, but I would preface it by saying this confidentiality exception doesn't deal with costs at all. This confidentiality exception deals with requests for authority to incur expenses which may or may not then be incurred. Okay, and that's a really important distinction when we're talking about what is actually being shielded from disclosure. So I did indigent legal defense for a long time, as some of you know. I bothered Mr. Parr frequently in that role. And I sometimes I would be the second attorney, the third attorney for a client. And I would make my request for expert authority or some other kind of, or an investigator. It was often the case that the initial authority that was granted to, say, the first attorney hadn't been expended. I made my request to ensure that I could do my job without having to go back and do an accounting with somebody else who's may or may not be immediately responsive to me. But the fact that there are multiple authorizations in the same case does not necessarily imply that all of those authorizations are expended in full. It's possible in some instances they may be. That's number one. Number two, yeah, there is room for disclosure of information related to these authorizations after a case is concluded. And in fact, the statute already calls for that. So once it is no longer possible for the prosecutor to get some information and figure out what my trial strategy is, then the executive directors, and I'm not usually talking about myself in the third person, but I put myself in the wrong part of the example. The executive director's decision is subject to disclosure. And so at that point, it is reasonable to disclose that. My first choice as a defense attorney is instinctively to say, no, let's disclose nothing ever. But I do think that it's reasonable to disclose it there. And in terms of the transparency, it is certainly possible to aggregate data or de-identify certain data. And in fact, we do that. If we got a FOA request that called for how much money or invoices to an investigator, a particular investigator, or all investigators, we would have to answer that. There'd be a lot of redactions because investigators' invoices that reach me for review typically have notes about what they did. And sometimes there's information in there that would be confidential under one of the other subsections in the statute. We'd go through that, line those out. If it was an investigator or another kind of expert in a child protective case, we'd take out the docket number and the parties, kids' names, that kind of stuff. But that kind of information is available and is not shielded by this provision.
Is that helpful, Eric?
Yes, it is to me. Hopefully that kind of prompted some clarification for the rest of it, the benefit of the rest of us too.
Okay. Thank you. Linda, you have a question?
Yeah, thank you. I'm just curious, is there an annual report of expenditures or a quarterly report? How does it work at your end for releasing those numbers, aside from a FOIA?
In a number of ways. So monthly, we have a report in our commission packet, which is available on our website, available to the public on the website. And also there is an interested parties list. So if you wanted to be, or journalists wanted to be on the interested parties list, we would distribute that to them in advance of the hearings. In there is a breakout of all of our accounts, and there is, I think for these lines, there is costs for the month that we're in, for the quarter that we're in, and for the year to date. And so all of that information at a high level is available there. We do not produce a report annually of all of the investigators that we paid and how much we paid each investigator, and we don't produce a report organized by client. A couple of reasons for that. Principally, we would need headcount to do accounting at that level that we don't have. But we would answer a FOA asking for that information. We couldn't do it quickly, but we would certainly honor that.
Great. So did that help, Linda?
Thank you.
One question I had, and then I'm going to ask Judy to maybe we wanted to talk about this because there was a concern that Judy had that we wanted to make sure we had at least tried to make a chance today to address. I don't know if you had a chance to see it, Justin, but Judy had forwarded some examples of news stories that had been run where, as I understand it, and Judy, please correct me if I'm wrong when you speak, but it seemed like some of this information was publicly disclosed, and it seemed like it was even publicly disclosed during the course of a case being litigated. I did. Did you have a chance, Justin, to see those news stories?
Yep.
And is that a different type of information from what this exception is talking about?
Not clear to me whether, and I don't have it in front of me, and I won't keep looking. I was trying to pull up the other report so I could show it to anyone who wanted to see it.
Sure.
It's not clear to me whether there was information disclosed there that I think should have been covered by this.
Okay.
I will say that I am doing my best to be consistent in my application of exceptions to FOA requests or other forms of requests. I answer lots of requests on our portal, FOA requests, as frequently as I can. And, over time, some of those have evolved. I've never been in state government before. I've never had to think through the process. And now I know how many people I've tortured with my FOA requests in the past. But there are instances where my perspective on what's covered by our statute is different from what Director Pelletier's opinion was. And so in those instances, I tend to document why. And why I've made the decision that I've made and then implement it consistently. But it is possible that with respect to the Cleveland Crothers stuff, information was released that I might not release. It's a long way to get to that answer, but I thought it was why it could be different.
It's a perfect answer. It does help me understand a bit better. So thank you. Any other questions of subcommittee members at this point? I don't see any. So Judy, welcome. I'm going to see if you would be able to kind of share your thoughts, at least based on what you've heard and just in general about this.
I'm happy to, Chris, and thank you for the invite. And this came to the attention of Right to Know innocently enough because OPLA staff brought forward just examples of language across a number of disparate statutes, so we could kind of align some of the language that we use just to make statutes more clear going forward. And this was one of those examples. It wasn't pulled out purposely. It was just one among many examples of language. And because I covered the Cleveland Crothers trial, and I remember the judge saying, no, we're not going to give you a new team of lawyers. We've done this 3 times. We've spent enough time. We spent enough money. And I remember getting those financials. So I was just surprised to see that those requests were confidential. Because I have a concern, you know, anytime we shield expenditures of taxpayer money, that we ought to look at that. And given, you know, the recent media coverage of some of the financial challenges in the Office of Indigent Legal Services, more of which we heard at the hearing yesterday, I just thought it was worth looking at whether there's a way to divulge that information without revealing courtroom strategy or without compromising defense strategy in any way, but that the public would get to know how the funds were being expended. Even, you know, not investigators by name, just like this case has spent so far, you know, $6,000 on private investigation services, but not for what and to whom. I just think it's worth considering.
Justin, what are your any thoughts on that? Thank you, Judy, by the way.
I have a couple of concerns about how to do that. I don't have any reservation about sort of sharing the light. To the journalists here, my approach to the press has been very different than my predecessors. I have yet to turn down an interview request. I have yet to, some questions I can't answer, but I'm doing my best to be much more transparent, even where we get blemished as a result of that. So that's step number one. Step number two is the requests are not expenditures. And I know I said that earlier, but I want to say it again. By the time it's an expenditure, the case is generally at a conclusion or nearly at a conclusion. And so there's a close temporal relationship between when we actually spend money and when the public might be able to find out what we spent. The authorizations are just that. And I would frequently request authorizations I didn't use. I might set out down a road and say, could I have an expert of this sort? And John or Ellie might have said yes. And then I realized I didn't need to go there. So it's really a little problematic if the interest is in observing the expenditures to tie that to those authorizations. The authorizations, the place to control the authorizations is through statute or rule related to my exercise of discretion. I invite input there. And then I might push back against it, by the way, because I think defendants need to get what they need, but that dialogue could be robust. And then I can, have oversight in terms of how I do my job in making those from that place. And then could be revealed what had happened. There is a genuine risk in merely showing that somebody's getting ready to spend money on a case. I have had cases where I have done my best to look to the prosecution like I got nothing. Well, I have gone off in a corner and built a case in the hope that they won't pay attention, and that if I have to try, and I get away with it. There's a lot about the practice of law that involves more poker than is politic to talk about, but that's the reality of the practice of law. And so I would be very, very, very reluctant for anyone to know, even that, I had $10,000 in experts lined up on a case. And even if I'm not going to spend the money, $10,000 of experts available to me, because it does reveal enough to maybe get a prosecutor interested in what am I missing? Is there something here that I can explore, or should I just be paying more attention? I hear that. And if I were not in the role I'm in, I would say, well, don't we want the prosecutor doing all the work on all the cases? And of course we do. But the reality is that's not how it happens. So there really does have the potential to trigger a response that's problematic for the defendant. So when those authorizations go out, we don't write checks. The expert does the work. The expert invoices the lawyer. The lawyer represents that the work was done acceptably. The invoice is forwarded to us. We process the invoice and the vendor is paid. And so that processing generally happens quite late in the case or after the case is over. So that transparency is coming pretty close. Like I said, it's linked pretty closely temporally.
So at some point, to use your poker analogy somewhat loosely, you do have to lay your cards down on the table, but it's just not, it's toward the end of the process, not at the beginning. if that analogy even makes sense.
It does, except that it's even a little bit different because it's the lawyers who are playing poker. All that's happening is that the lawyer's coming to me and asking for a marker. And so, you know, by saying this is the marker I gave the lawyer, the prosecutor or the child protective attorney general has the opportunity to know that the person they're playing with has a war chest and maybe they need to go do the same. And so I'm not the poker player in the analogy. I'm the house. And so, but you're my shareholders. And so once the game is over, I have to reveal to you what I approved and what was actually spent and what the consequences of that were for the public. And again, I don't have any reluctance to that, except that certain little things need to be redacted. But you know, we produce that information.
And just to make sure I'm clear in my mind, because my coffee is starting to wear off a bit, is the statute that we're talking about at issue here, is that covering the expenditure information or the authorization information? And if it's not the authorization information, is that covered by another statute?
It is the authorization, not the expenditure,
okay,
that is made confidential until the case is over by Rule 1806. Now, if you come and ask for me for the expenditure during the case, which nobody's actually done to my knowledge, I don't know how I would answer that, because there's another exception, and again, I don't mean to multitask, I'm trying to get that back on my screen. 1806 has an exception for information that would be privileged or confidential under the rules of professional conduct, Rule 1.6. So arguably, attorney's trial strategy, which extends to the experts and investigators, would cover that. So I think, I haven't thought this all the way through, but I think if I got a request, not for the authorization, but for any bill that had been paid for a particular case that was still open, I would likely conclude the entire bill was exempt under 1806 2B, Bravo, until the case was over. But I would have to really look at that in the context, see what was being requested, see what the documents really were, and think about, you know, whether anything could be disclosed there. But 1806 2E, which was the subject of the inquiry, applies only to the authorizations.
Okay. Judy, what are your thoughts at this point based on this, which this has been really helpful, Justin, I appreciate it.
Sure.
Absolutely. And I also believe defendants should get everything they need in their defense, and that they should be able to do that, you know, with their attorney and create their own strategy without, you know, observation. So I just wonder if the language needs to be clarified a little bit so that it's really clear that it's merely the request and not the expenditure. I don't know if that's even necessary, but it took this full explanation from you, Justin, for us to understand what it is that's excluded in that line. So I don't know whether that's necessary.
I don't know if it's necessary. It could certainly be helpful. And I'm into helpful even when not absolutely necessary. I hope over the next year for presentations, the next full legislature, to be able to rework our statutes in their entirety. And that will include these confidences, because there are other problems here. For example, what information I can disclose when I write a decision suspending an attorney about investigative material. It's not what we're here for today. It's an example of a place in this particular section where there's a problem. And so it would make sense to me when we do that to rework this provision to make it clear it applies just to the request. So whoever wrote it probably thought that because it uses the word request and not payment. But unless you're insider system, you would never know that that was the distinction that mattered. Yeah.
Yeah. Yeah, I agree. And I think we all appreciate your interest in looking at the statute sort of through those eyes of, you know, what might we make it different, you know, better in terms of transparency and access. So thank you. Kevin, it looks like you have a question, and then Eric. So why don't you go ahead, Kevin? Kevin, did you still have a question?
No,
Yeah,
I do.
okay.
I guess, so I'm just trying to determine whether I think there's any issue here. So if we were to go back to kind of to Judy's scenario where somebody's sitting at a trial and they hear the judge say something about, multiple expenditures of cost. If they were to request for that information after the case is over, they would get the costs. I guess that's really the question.
So yes, the cost information would be redacted to remove information pursuant to 1806(2)B that would be subject to privilege or would constitute a confidence or secret. So folks talk about privilege with lawyers. Privilege is really an evidentiary rule that determines what can be introduced at a trial. The lawyer's duty to maintain the secrets of a client is contained in Rule 1.6 of the Maine Rules of Professional Conduct. My last job was at Bar Counsel's office, sorry. But it defines secrets and confidences differently and includes the concept that any information that, if revealed, could be harmful to the client is protected. So I would then need to go back and look. And it would depend when it was coming. So it would depend whether there was a post-conviction review, whether the case was on appeal. If the judgment's not truly final, the constellation of information that has the potential to have a deleterious effect to the client is broader than if the matter has been brought to a true and final resolution. So that would be a very case-specific, document-specific determination. But the short answer is there would be a production of everything that could be produced consistent with that premise and without consideration of 1806(2)E. It would no longer apply. The case is over. The documents are not requests. That would be off. And the request for the requests themselves, challenging sentence, we would honor at that point.
Is that helpful, Kevin?
I think so. I'm hopeful it might be helpful to kind of our press colleagues here, in the sense that I'm not sure anybody's asked. Maybe this is how it was brought about, but I'm not sure anybody's really necessarily interested in the requests, but they would be interested in the costs that are expended, because that seems to be what's of the public interest here. So I guess I'm just trying to figure out, outside of this exemption, because this exemption clearly doesn't seem to apply necessarily, but whether there's any issues there or whether we need more transparency.
I think there are two different sets of inquiries that come from the public and from the press and from the government, other aspects of the government. One has to do with the financial stewardship. The other has to do with the quality of client services. And the requests are indicia of the work that the attorney did and speak, in addition to what was spent, speak to the question of the quality of service. The payments may speak to quality of service and also speak to the financial stewardship. And the request can be interesting to determining the competence of the representation. If I had a case where there was a dog sniff, for example, that had led to an arrest, you'd want to see that I had asked for funds to talk to a dog sniff expert, perhaps, to be able to assess whether I thought the search was good. So I will say it goes both ways. I'll also say that, underlying this conversation is a tension that I don't think exists with any other agency in state government. The right of the public to know, the statutory right of the public to know, and the vindication of the First Amendment and the press, which is, my father worked for the firm that did New York Times v. Sullivan. I grew up that the press is really paramount to our functioning society. Here, the countervailing argument is not a statutory sort of privacy exemption. It is also the Bill of Rights. And so there is an additional sort of different tension in the release of information here that doesn't exist if we're talking about building a bridge. And it's really the only place I can think of where we run into this particular tension in vindicating two fundamental liberty interests at the same time. So I just think about that as we think about how to do it.
Yeah, I appreciate that, Justin. Eric, why don't you go ahead?
Yeah, so Justin, a question for you and then to Peggy or Colleen. So you mentioned that you're going to be looking at the entire statute that governs the commission. And I presume that you'll be considering potential language to see whether some of the confidentiality things that are mentioned need to be, clarified a bit.
Yep.
And so the question for Peggy and Colleen would be that those proposals would go through the Judiciary Committee, right? And then they would apply their 7 or 8 standard FOA type questions. And then it might come back around to the Right to Know Committee. I know you sometimes, you have a practice of at least alerting us when there's a bill in the mix that has confidentiality provisions. So that's a long-winded question, but I'm just talking about the next step, about that we might see this again, sometime in the next session, possibly.
Just to confirm, Eric, if Justin puts forth legislation in the 131st legislature, if assuming the Judiciary Committee follows the same process that is kind of dictated by the statute, then the bill would probably go to the Judiciary Committee, but they would apply those criteria just like that are in the statute about doing the weighing, the balancing, maybe it's not balancing, the weighing of the different interests to determine if it makes sense for that confidentiality provision. So that would come up. If it doesn't, if it takes longer to get that legislation rewritten, Title IV is up for review. We have to establish a new schedule once we get through Title 39A. But in another 8 years, you'd be looking at it again, I think. Or if somebody brings in a bill sooner than that, not Justin's rewrite, but somebody else is concerned about clarifying this, then the Judiciary Committee would apply those standards.
May I say
Yeah, go ahead.
So it's in bad policy to have a statute whose acceptable implementation relies on the individual at the pointy end of the statute. And so I don't suggest that. But I do want to articulate that, in my view, the biggest failing in MCILS before I came here was in its failure to be transparent. We have a lot of problems. We had a lot of problems when I got here. We still have a lot of things that we're working on. We didn't have actually nearly some of the problems that appeared that might have been. There was a lack of transparency that led to a sense of gotchaism with what we were doing. I accept the we, even though I wasn't here then yet. In this, as it goes now, whether you choose to recommend changes or not, my goal is to be as utterly transparent as I can be, consistent with my other duties. I spend a lot of time doing that with lots of journalists and with individuals, because I think that the best way for us to demonstrate that we are in fact serving the mission we're designed to serve is to provide people with that access. And so while you make your decision, I just want to reassure you all that if I can produce a document, I do. That's just my philosophy toward it. But for so long as I'm executive director, that's what you can expect from me.
Thank you very much. Appreciate that. Linda, did you have a question? Your hand was up before. I just wanted to make sure.
Yeah, thank you. No, I got a bunch of that answered by Peggy. Appreciate it and appreciate the conversation. I think it's really important. Thank you, Judy, for bringing it up. So I realize that a lot rests right on your shoulders, Justin, and whether things get moved forward, it's policy or statute, but hopefully see something. Because the financial stewardship is, I think, is paramount for the taxpayer. So thank you.
Thank you.
Yeah, I agree. Thank you, Judy, for bringing this forward. And Justin, thank you for being here and for your enthusiasm and dedication. Really appreciate it. I suppose the question then is, what do we want to do, if anything, by way of a recommendation?
Excuse me one second. I'm going to excuse myself and run off to Clack. Thank you for having me.
Okay. Take care. Good to see you. And I would ask Judy, since you are a member of the full committee, if as far as I'm concerned, you're welcome to weigh in on what recommendation the subcommittee makes. But I guess that's exactly the question I have at this point, and certainly we can discuss. But what, if any, recommendation should we make with regarding this provision? Any thoughts? Judy?
Given Justin's assurance that they're already working on clarifying the statute, I think if our report just notes that we had a check-in with him, I will say he is far more accessible than his predecessor. And I'll take him at his word that the work is underway. We make a note in our report, and I think that satisfies the concern for me anyway, but that's my 2 cents.
Yep, no, I appreciate that. That's very reasonable. Anyone else have any thoughts? Is that the way we want to go? I don't see anyone objecting as a way to go. So, and I think I've learned enough, but maybe I'm about to prove myself wrong, that we don't have to have any kind of motion or anything or vote on that. We can just ask staff to do what Judy just said we should do. So, all right, great.
Well, thank you for taking this up. Much appreciated.
Oh yeah, absolutely. And thanks again for bringing it forward. I think I certainly learned a lot about that provision myself. So it was great. Thank you. You're welcome to stay, or I know you're busy with other things, but whatever you'd like to do.
I'm actually off this week, so I'm gonna get back to Christmas shopping.
Oh, okay. Excellent. Good for you. Take care. See you soon.
Thanks a lot.
All right. Bye-bye. All right. So why don't we move on right away to the next agenda item? And while I'm looking at the screen for that, I'm going to ask our public access ombudsman to introduce herself. Brenda.
Thank you, Chris. I apologize for being late to the meeting. I'm Brenda Kelty. I'm the Maine Public Access Ombudsman.
All right, excellent. Thank you for introducing yourself. And I think the next item on the agenda is I'm working off an old agenda. I'm going to admit right here, because I'm not quick enough in looking up things on my computer, but I think I'm about to be right. It looks like we're due to discuss reviewed table public records exceptions from titles 8 through 12. And I hope someone corrects me if I'm wrong. And I have, just so you know, I have an injured friend here today who broke her elbow. So you might hear every once in a while someone in the background. So just to let you know, that's what's going on. So did I get that agenda item right?
You did.
Okay. So why don't we who's the lead as far as OPLA staff on that?
I think it's me.
Okay. So Colleen, maybe if you wouldn't mind walking us through, that'd be awesome.
Sure. As you mentioned, there were 4 tabled exceptions in the review that you did of titles 8 to 12. 2 of them were within Title 8 that related to records of the Gambling Control Board, and 1, which was reference number 4, related to information and records required by the Gambling Control Board and provided confidentiality for information that was trade secrets or proprietary information that, if released, could be competitively harmful to the submitter of the information. And you tabled the discussion of that exception because you were thinking about the question of whether or not you should recommend a sort of global, I think, definition or a global exception for proprietary information. And at your last meeting, you had that discussion, and I think decided that you would set aside that effort and just maintain the existing language in the exceptions that relate to proprietary information. So I think that you may be able to address this exception to be consistent with the recommendation of the Gambling Control Board. That was that the exception remain without change. But I think that's where you are with this one.
Okay, yeah, no, that's great. That's perfect. Thank you. So it sounds like we kind of tabled it with this thought that we were going to have this discussion about the sort of the bigger issue. We had that discussion, and now these are still on the table. So I guess first, it probably makes sense to take them off the table, right? And do we need a motion for that, or?
I don't think you need a motion. No,
Okay.
I think you're all set.
So I'm just going to take them off the table. So that having been done, I guess it sounds like that unless there is thought that there has to be discussion further about these particular exceptions, other than the proprietary information aspect of it, that wording part, that we should have a motion to possibly recommend accepting the recommendations of the Gambling Control Board, or a unit, I should say.
Yeah, I think that would make sense, and we'll sort of take them one at a time.
Okay.
There was, if you want to take the two Gambling Control Board exceptions together, which you could do, there was a second one that you tabled that related to, touched on personal contact information, and that sort of was part of your other aspect of your discussion about making potential global exceptions for personally identifiable information. And I think consistent with what you decided about proprietary information, you were not going to take any further action to amend Title I, Section 402, subsection 3, and the definition of public record generally with regard to that one as well. So I think you may be able to take action on both of these in Title VIII if you're comfortable. Again, with the recommendation of Gambling Control Board for both of these exceptions was not to make any changes, just to maintain the existing exceptions.
Yeah, if only as a matter of efficiency, but I have other reasons. I think it makes sense to take them both at once. Does anyone have concerns about taking them both at once? And seeing no concerns expressed, I guess what I'd be looking for is a motion to accept the recommendations. Julie, I'm seeing your hand up. Is that a motion or a
Yes,
question?
I will make that motion to accept the recommendations of the Gambling Control Board on the two exceptions just noted by Colleen. I think the reference numbers are 4 and 11.
Yep, that's right.
Great. I have a second.
I'll second.
Okay. Any discussion? Seeing none, why don't we go ahead and vote? And this is a roll call, I think, right?
It is a roll
Okay.
call. Yeah, I think you will need to do that. I'm happy to do it. So the motion is to accept the recommendation of no change with regard to reference numbers 4 and 11 within Title VIII. And a vote of yes is in favor of the motion to make no changes. And I'll go through and call the roll really quickly of the members who are here. Chris Parr,
Yes.
Linda Clancy,
Yes.
Kevin Martin,
Yes.
Eric Stout,
Yes. Yes.
Jonathan Bolton. Thank you,
Yes.
Eric. And Julie Finn.
Yes.
So that's unanimous of the 6 members present.
All
Thank
right. Great. And are there 2 others? Is that?
There were 2 others, and these were within Title 12, and these were 2 exceptions where you actually considered making some changes. And so I did share the proposed amendment language with you, but I also was able to share it with the Department of Marine Resources in advance, and they were able to clarify. Do you want me to pull that language up so you can see what the amendment language is as I discuss it? Is that
Yes,
helpful?
that'd be great. Thanks.
Okay. Sure. So I'm going to share my screen. I think everybody should be able to see this. So there were 2 exceptions, and the first one dealt with notification of leases that are granted by the department with regard to aquaculture leases. And in paragraph D here, this is the exception that the committee was responsible for reviewing. And the current law states that upon that the seeding and harvesting reports that are submitted to the department are confidential, but the language provides that upon written request, the department shall provide a copy of that report to the municipality or municipalities in which or adjacent to which the lease is located. And the question came up at your first discussion as to what was the responsibility of the municipality to maintain the confidentiality of that report. And you suggested that perhaps the statute should be clarified so that the confidentiality was maintained by the municipality. And I confirmed with the Department of Marine Resources that when they share the report, it is their expectation that the municipality will maintain the confidentiality of that report. So they were amenable to clarifying the language here, which is highlighted in the yellow, that states that the department shall provide a copy of the report to the municipality. And if the suggested language would add that as long as the municipality or municipalities agree to maintain the confidentiality of the report. So that's the first exception. And if you are, for purposes of your discussion, I think consider whether you want to recommend an amendment to this exception.
Great. So in my mind, it probably makes sense to do these one at a time.
It does. Yep.
Yeah. So I guess maybe at this point, why don't, if you wouldn't mind having us all go back on the screen.
Absolutely.
So, and does anyone have any thoughts on that language? Looks like everyone is comfortable with it. So I would.
Chris.
Oh, yeah. John.
I think I'm comfortable with it. I just, the only thing I would point out is that you could, in theory, have a stronger version of this, right? That says municipalities shall, keep the report confidential if it's provided to them. In this case, I think we're talking about a government entity. I think we can assume that if they agree, they're going to do it. So I don't have any issues with it, but I just point that out.
Chris, I'd actually echo that as well. I think that was my only reservation with the language is, there's language that so long as the municipalities agree, and coming from a state agency perspective, I would worry about, well, what does that mean? We're required to under, not this being my agency, but if the DEP are under this, I'd see that as I'm required to provide this to the municipality so long as they agree, but I don't, if they were to disclose this, what would they have had to have done such that I'm not in violation of that statute? Whereas, Mr. Bolton's solution seems to solve that problem, which is I'm required as a state agency to provide this report and the municipality is required to not disclose it. So in terms of whether there'd be a preference, I think that's where I'd come out as well.
Yeah, no, those are great points. I think I had started to think about that a little bit, but I hadn't had time to think much about it. But I think those are great points because in my mind, as I hear both of your comments, it does make me wonder, does that have to be like a formal agreement? Like we have to enter into like a memorandum of understanding or something or agreement? So what would, I guess maybe Colleen, it sounded like you might have some ideas based on.
We can certainly, replace the language, amend it as you've suggested. And, maybe just end the sentence where it says which the lease is located and then start a new sentence, that says upon receipt of a, report, the municipality shall maintain the confidentiality of the report, you could do it that way. You could say, or you could do it, shall provide a copy of the report to the municipality and the municipality shall maintain the confidentiality of the report. You could do it that way too. Combine the sentences or make them into two sentences. But I think the concept of the duty, you're making it clear that the municipality has a duty that they shall either shall maintain the confidentiality or the municipality may not disclose the report received by the department. There's two ways to.
Yeah, I like both of the ways. For some reason, the second way sounded, it seems like maybe it's the way I'd write it, but I like it.
More clear,
Um,
may not disclose.
Or
Yeah.
shall not disclose or
Shall-
whatever.
I can't do
whatever
shall
the-
not, but
Yeah,
I can
that's
do
right.
may
It has
not.
to be may not, right, okay, that's right. John, Kevin, any concerns with that approach?
I mean, I guess my only question would be if there was some reason, this is the agency that suggested the language that's in here now.
No, I mean,
No,
I
it-
think that I was
Okay.
taking this is an example from how it's phrased in another area of the statute.
I see.
When, one state agency is receiving a report from another state, for example.
Right.
And this is consistent with how that language is phrased, that they can get the report from the other state as long as they maintain the confidentiality of whatever information they receive. So that's where I got that language, and then I shared that with DMR and they were comfortable with it. So it wasn't necessarily something that they suggested initially.
I see.
Yeah.
I mean, given that, I think I probably would lean towards one of the formulations we just talked about. I don't have a strong preference for which, but I just think it simplifies it a little bit. Again, I don't really have any serious concerns that a municipality under the statute is going to do anything differently under either version of the statute. But I think just as a matter of, I think it might make a little more sense to just have it as a separate requirement.
Okay. I'm fine with either of those two approaches. I guess it sounds like I think we're all in agreement based on the conversation so far that one of those is the better way and the way we'd want to go. So I'd be comfortable with, do we have to have a motion to go with that language? I know it's not going to say what I just said, but go with that language, or can we just agree to it and then maybe vote as a full committee if it's brought to us then, at the full committee meeting next week? Or what's the best way forward? I guess I'd look to OPLA staff.
I think you could do either. I mean, you could certainly make the motion to recommend, describe what your amendment is, and then have it be subject to the full committee's review next week. We can certainly share that, share the draft after the meeting today. But absent, I guess that would be the way to do it, absent trying to or necessitating that you would have to have another meeting to look at it again.
Right, yeah. Does anyone want to make a motion to that effect? Or is there a preference to have another subcommittee meeting, which I know they're so great to have? Anyone may want to make a motion?
I mean, could we make a motion to just ask subcommittee staff to draft, to redraft the proposed new language so that it's a separate requirement on the municipality as opposed to a requirement to agree? Would that be sufficient to
It would.
give you direction? All right, I would like to make that motion then.
Whoops, all right, do I have a second?
I'll second.
All right, we have a second. Any discussion? Seeing no one wanting to discuss, let's have a roll call.
Great. Doing the roll call, the motion is to amend the proposed language to make it clear that the municipality has a duty to maintain the confidentiality of the report received. Chris Parr,
Yes.
Linda Clancy,
Yes.
Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Eric Stout.
Yes.
Great, that's 6 members voting in favor. So that's unanimous of all of the subcommittee members present.
Okay, excellent. Let's move right on to the next item on the agenda then.
Great.
Whoop, I'm sorry. Was there a?
There's another exemption.
Oh, yeah, that's
from-
right. Let's not
yeah.
move on to the next.
Title 12, yeah.
Let's-
Want
yes,
to do that quickly? All right.
Yeah, let's do that one. Sorry.
Okay. There's one more in Title 12 that related to the Department of Marine Resources that you discussed. And the recommendation this was one of the very few, I think, where we got a response back from the agency where they recommended a change to the statute. And here they recommended that they would be comfortable with repealing the confidentiality language because they thought they have existing authority in another section of the statute that governs their ability to require and collect statistics related to licensees. So they had recommended repeal, and what we were unclear of as part of your discussion was whether they were suggesting repeal of just the reference to confidentiality, which is the last sentence of this subsection, or if they were recommending repeal of the whole entire section that relates to the requirement for reporting of data by sea urchin buyers and processors. And I was able to follow up with the department staff, and they did confirm that their suggestion, which they are comfortable with, would be repealing all of section 6749S, which relates to the department's authority to adopt rules and require the reporting of this logbook data back to the department. And they are recommending repeal because they have existing authority in their general statutes to collect and report statistics related to those entities that are regulated by the department. So the recommendation, if you are amenable to it, would be to repeal section 6749S.
Okay. So my immediate question, I guess, when I look at that is, do we have the authority does the Right to Know Advisory Committee have the authority to repeal an entire section other than that provision about confidentiality, that's there? Because that's a lot of stuff there that, from what I could see, that doesn't, it's about applications and this other substantive stuff that we have no jurisdiction over, either as a subcommittee or as a full committee. So I guess I would turn to my fellow subcommittee members to see what their thoughts are on that, if any. Eric.
Yeah, I was going to say the same thing and suggest that maybe our authority is just that one sentence that Colleen just highlighted a minute ago about disclosure, because that's our focus and our authority, and that we leave to others, the Natural Resources Committee or whoever, to decide or to even recommend about whether to accept the larger repeal. But so I'm agreeing with Chris that we just focus on that one sentence that's about the disclosure.
Thank you. John.
Well, I guess that the question I have is, and I agree completely with Eric, I'm not comfortable taking a vote on the repeal of that entire section. And I think it's beyond the scope of our mandate. I guess what I'm wondering is, do we know the position of the agency on repealing just the confidentiality provision without repealing the rest of it?
So I did have that conversation with them. I mean, their initial suggestion was that there was no need for the whole section. But if the committee went forward with a recommendation just with that sentence, it would, and if the full committee accepted it, and then that went to the Judiciary Committee, and then there was an opportunity for a bill to be printed and input to be provided, that the agency could provide input at that time to the Judiciary Committee about potentially repealing the whole section. And that would be, they would get that opportunity to do that at that time. Because we did talk about that potential that, in the past, when the subcommittee has been faced with these types of suggestions, sometimes you've taken the approach where you haven't taken any action, or you've contacted the policy committee and suggested it, particularly with regard to entities that you might find are no longer active. And there's one that we're going to be discussing later that might fall into that category, in terms of an agency or a public body or a commission. So I think that if the subcommittee took the approach of just recommending the sentence, then the department would still have an opportunity to provide input about the potential repeal of all of 679S at that time.
Excellent. Thank you. And thanks. I'm glad you thought far ahead like that, thinking about this possibility. Eric.
Well, having said that, then since Colleen has done reconnaissance with the agency and they have the intent of saying that that could or should be repealed, rather than us picking out just, kind of picking that apart, maybe the better approach is for us to just say, we defer to the agency to work with their committee of jurisdiction and, bring forth what they recommend as changes to the larger section, rather than just, taking out the confidentiality, the distribution portion of that, messing with that, knowing that there's something that they intend to do, to just, defer judgment. So maybe that's the approach we take.
Yeah. John.
So I have another question.
Sure.
Colleen, do we know whether the agency is just sort of actually would like to repeal this bill and will be putting in legislation, or whether it's just something that they're indifferent to, and that if we were to propose something, they would probably seek to have the whole thing repealed?
I think the agency was more interested in the potential that the Right to Know Advisory Committee would put the bill in kind of for them on their behalf, and would prefer that as opposed to trying to seek their own legislation. That's just sort of, my impression of sort of the preferred approach that they might think they might want the subcommittee to take, but they certainly would have the opportunity to, if you declined to take the opportunity now, they would have avenues that they could pursue to repeal the section.
The thing that this raises in my mind is, if we were to just do away with that sentence, does that kind of create some ambiguity at that point? I mean, because it sounds like they think they have the authority somewhere else, but you still have these records being treated under what would remain. It seems like, I guess I'd be inclined to not to just to keep things as they are, not recommend anything. I guess not. If they're recommending repeal, I guess I would say recommend not repeal. But anyone else have any thoughts? Linda.
I'm sorry, did you just say recommend? We would recommend not repeal? I was confused.
Yeah, no, I can be confusing. That we recommend that it not be repealed, that we do nothing with the statute as it is what I was thinking.
I think I'm inclined to agree. I don't feel I have the expertise or knowledge or authority to do anything with this, and not knowing what they really want to do. I think it's up to them to grapple with it.
Yep, I agree. Julie, did you have your hand up, or?
Yeah, just agreeing with both you, Chris, and Linda. Sorry about the barking dog. I think this is more of a department bill than something that should come from us, which I think is what everyone else is saying.
It sounds like the dog is in full agreement, so that's even better. Okay, do we need a motion to do nothing?
I think we do. I mean, I think
Okay.
that's what we've been doing. So a motion to accept no change to the current statute would be in order based on your discussion. My only question is whether or not you wanted any sort of follow-up beyond with the department, which I'm happy to do on your behalf. But Eric had suggested possibly communication with the policy committee. I don't know if that's something you might want to include or do as in addition to the motion.
Yeah, so it sounds like we would need a motion that's sort of a two-step approach of recommending no change and recommending that communication be made suggesting that the Department of Jurisdiction possibly submit legislation to address this provision. But I can't make that motion. So.
I'll make that motion.
All right. Well stated. Do I have a second?
I'll second.
All right. Any discussion? I'm going to be quick with my any discussion looking around process. I see no discussion wanted, so let's have a roll call, please.
Great. So those in favor of the motion, Chris Parr,
Yes.
Linda Clancy,
Yes.
Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Eric Stout.
Yes.
That's 6 members voting in favor of the motion. That's unanimous of the members present. Thank you.
Okay. Excellent. Thank you, Colleen.
You're welcome.
All right.
That is
Now
it
we're
for
going on, I
those.
think, to the next item on the agenda.
We are.
And I believe this is sort of getting back to our table of exceptions and recommendations and such for titles 20A to 21A. I believe the reference numbers that are involved are reference numbers 44 to 74.
That's right.
Assuming that everything I've just said is correct, the way I'd want to proceed is if there's any of the reference numbers that anyone wants to identify at this point where some discussion is thought needed or there are questions. I will start with me because of course I have some as always. Reference numbers 61, 67, and 72. That's it. Linda, do you have any?
I think, sorry, the number, I think it's 52.
Right, 52. Kevin? You're on mute.
I actually had a note about 52 because I thought it was a good example of one of the rare circumstances where not a public record might make sense to be used. It was kind of one of those examples where I was thinking of the other day where maybe the legislature pointed to an entity and defined its scope and said their records aren't public records. In that case, it might make sense. But so that's the only one I had about that. I didn't know if we wanted to discuss some of the school kind of employee exemptions. So I had listed 47, 48, mostly 48.
Okay, no, we can discuss whichever we might have questions or concerns about. Absolutely. John.
Let's see, I'm not muted. Good. So I think we should discuss 48 just because MSMA seems to think there should be some change to it. So that would be my suggestion. A lot of these are statutes that my clients administer, so I don't have any suggestions for any of the other ones, but I'm happy to answer questions about them.
Okay, great. Julie?
No, I'm all set on these. I will just participate in those that others have pointed out.
Great. Eric?
Yeah, I don't have any questions or objections to any of them. I did read them thoroughly, but I'm interested to see what the others would say about the numbers you mentioned.
Okay, great. So I would look for a motion to move everything as recommended other than the ones that we've set aside just now. We have a
So
motion.
moved.
Okay, I have a motion by John, a second by Julie. Any discussion? Seeing none, let's have a roll call, please.
Great. So these are to accept exceptions 44 to 74 without changes, except for reference numbers 47, 48, 52, 61, 67, and 72. Those are the ones we're going to set aside.
Pauline, if I can interrupt 1 second, I think I got my numbers wrong. So
Oh.
I think you can add 47 to that list and keep 48. So
Oh, take out 47?
Add 47 to the ones that we are
Gotcha.
moving.
Gotcha. So just take out, just reserve 48 for further discussion.
Right.
Okay, great. So just to clarify then, we're going to be accepting all of the exceptions within 44 to 74, but carving out for further discussion 48, 52, 61, 67, and 72.
Yeah, and I'll accept that as a friendly amendment, by the way.
Great. Thank you.
And the second, Julie, you're okay with that friendly amendment? Okay, I
Yes.
think we're ready.
Okay, great. So those in favor, Chris Parr,
Yes.
Linda Clancy,
Yes.
Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Eric Stout.
Yes.
Great. So that's 6 of the members, subcommittee members present, voting in favor, and that's unanimous of all of you. So then we're back to the 5 remaining exceptions. And if you're going in numerical order, the first one's 48.
Yes.
Which does relate to education records. I would note that unfortunately, Vicki Wallach is not here, who is both a member of your subcommittee and was also the person who I think provided the questionnaire and the input from MSMA. But I know she may have had some earlier communication with you, Chris, about this that I'm remembering, maybe at a prior meeting, I'm not sure. But I'm happy to, as you go through your discussion, if you want, I'm happy to pull up the statute for you or whatever, however you'd like to proceed. I'll follow your lead.
Yeah, why don't we, I'm going to open it up to those who, I can't remember who, it might have been Kevin or Linda, who,
It's me.
or it was John, or it was John. Sorry.
I think more than one of us, actually.
Yeah, okay. So I'm going to open it up just generally to the, but for those of you who did specify this one, I guess I would open the floor up to just some discussion about like what your specific thoughts or concerns or questions were. And John, why don't you go ahead?
Sorry, can you just tell me what the reference number is that we're talking about?
48, I believe.
Okay, thank you.
So the comment that we received on this from MSMA indicates that this is a confidentiality statute that prevents local school districts from getting criminal history information from the Department of Education, who has an authorization to get it from criminal justice agencies to do their credentialing process. And they want, I think they're concerned that they aren't able to validate criminal history information that a person might disclose in an interview with a school. So I understand why that might potentially be a problem. What I'm a little puzzled about, and I don't know if anyone can help me with this, is that when I went back and looked at 6103, it looked like the information that the Department of Education received in terms of criminal history information from criminal justice agencies was public criminal history information. And so I understand that there's a provision that says that the information under that section can't be further disseminated by DOE, but what I'm not clear on is why the school district can't actually get that information directly if it's public criminal history information. So I don't know if anybody knows the answer to that, but that was my question about this concern.
I can try to answer that, but before I try, I guess I'd want to hear any other questions or concerns that there were about this provision or this reference number. Kevin.
Sure, real quick. I think there was another mention of potentially being there being problems here with recent legislation. I saw a public law number, but I didn't really, I haven't reviewed what changes were made and what the impacts were. So I didn't know if we wanted to discuss that. The other piece that I kind of flagged here, and I'm not an expert on what these records are, but it seemed to me that there was indications that these are commonly requested, which to me just flags that maybe we should be looking at it in the sense of what's being requested, why they're requesting it. Are there problems here with what's being disclosed? Anytime there's a common element that the press seems to be going after, or somebody seems to have interest in, I think that to me raises flags as to whether it should be confidential long-term or not. So I don't necessarily have a viewpoint on that, but I think it's something where, I think it could warrant further discussion.
Thank you. Any other comments on this reference number at this point? Seeing none. Oh, Peggy, I'm sorry.
Chris,
Go
yeah,
ahead.
I mean, I'd like to try to answer some of your questions. So the legislation that Maine School Management mentioned is the Fair Chance in Employment bill that just passed, which basically says you can't ask about a criminal conviction on an application. Once you've decided that you want to interview that person and you have them in an interview, then you can ask them. And it also doesn't prohibit looking for criminal history record information. So I don't understand what it means by the problem is we cannot validate that information, because they can, my understanding is they can contact the State Bureau of Identification for a criminal history record check at that point. If you cross-reference 6103, I mean, if you look at what 6103 subsection 3, that is the information that the commissioner gets for credentialing by using a fingerprint-based background check that goes through SBI to the FBI. The federal law says you can only get that information back, states, if you make those results confidential. And so that's what subsection 3 is. It's actually in compliance with the federal law. Otherwise, you couldn't get the national check, criminal history background check based on fingerprints back from the FBI. If the statute doesn't say you have to keep it confidential, FBI won't share that information. So correct that this information isn't really about school districts. It's about the department credentialing anybody who works in a school. So if school districts are relying on the criminal history record check to be coming from the department, I don't think that that's an avenue that can happen under the federal requirements. But there's nothing either in the Fair Chance in Employment Act or any place else that says a school district can't do its own criminal history record check by contacting the SBI and doing that public information check for Maine convictions.
Thank you, Peggy. Yeah, this is sounding exactly right. Yeah. No, based on what I know, certainly Matt Ruel, the director of SBI, knows much more on this than I do. But this is what you're saying is definitely consistent with my understanding. Is that there's a federal condition that's there because of the involvement of the fingerprint supported background aspect of it. And I also think one of the reasons why I know that law enforcement agencies need to, even if I'm say a law enforcement officer and I have a copy, I happen to have a copy of someone's criminal history record, I still have an obligation to inquire to make sure it's the most up-to-date record, because something that might be public one day, the next day might be confidential, just because of the sort of dynamic nature of some of those types of information. So I think that's why, but I think I didn't, this is helpful for me to hear as far as I didn't realize that the Fair Chance Employment law didn't prohibit the ability to inquire about public criminal history record information. So that's interesting. I hadn't even thought about that possibility. But I also think you're right, though, Peggy, as far as why, it can't be sort of a once removed sort of thing where a school district can get the information that from the DOE. So anyway, does that help, John?
Yeah, it does. And can I just offer an observation based on that?
Sure. Yeah.
I mean, it sounds to me sort of the bottom line here is that schools can, in fact, go and verify whatever criminal history information they learn about in a job interview by contacting the SBI directly for the state of Maine. They could similarly, if they find out about criminal history in other states through the interview, could call up those states, and if there's publicly available conviction information, could get that information. The reason why they can't get anything from the Department of Education is because some of the information held by the DOE is going to be, they are actually not allowed under federal law to provide to anybody. So we wouldn't be able to, there's really not much that could be done to address that, because we'd be violating federal law. So I guess taking all that, if I have all that right, I don't see much for the committee to do here, I guess.
I think that is right. And, I think a practical aspect, a real aspect, as far as, any aspect of life is there is a cost to having to inquire or run a background check. I think it's something like $32 for state level or $31. And if it's a federal aspect, I want to say becomes $54. I'm not sure how all those numbers, but those are the numbers that are coming to mind. So, there is a fee if you have to go direct, as opposed to being, I'm not saying that that's what's going on here, where there's an attempt to not have to pay. I have no idea. But that is, I would imagine, a consideration in general, as far as, whenever, do we run a background check or not? Who has to pay for it? Is it the applicant? Is it, so, yeah. Kevin, did you have any? I know you had.
No, I'm satisfied with those answers.
Okay. Okay, great. So I don't think at this point we necessarily have to have a motion, but we can move on to the next. Sounds like there's consensus that we do nothing as far as, or accept the recommendation to do anything. I'm not sure, was there even a recommendation to do anything, or is it more a concern?
I read it as more a concern.
Okay.
Yeah, me
okay.
too. Yeah.
Okay.
Yeah.
So it sounds like it sounds like the recommendation is to do nothing. So
Right. I mean, at some point you'll have to make a motion on all of these, but if you want to just keep going and do it all collectively at the end, you can do that, or take them one at a time.
Why don't we do them one at a time? That way there's no confusion later, because I'm confused a little bit right now. So I guess I would entertain a motion to make no changes, do nothing as far as this reference number is concerned. So we'll want to make that motion.
So moved.
Okay. We have a second.
I'll second.
Okay. And any discussion? No discussion. And can we have a roll call?
Great. So this is to accept reference number 48 with no changes. Chris Parr,
Yes.
Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Linda Clancy,
Yes.
Eric Stout.
Yes.
Thank you. You move around on my Zoom screen, so that's how I'm calling you out. So it's a different order every time. That's 6 members voting in favor of making no change. So that's unanimous of the members present. Thank you.
Excellent. Shall we move on to number 52?
I'm sorry, for whatever, my version skips from 51 to 53. Do I need to be looking at something different?
You're actually right. We did not get a response back on 52. So you're looking at the
Oh, I see.
questionnaire
Okay, thank you.
responses.
Okay, so I have to look at the chart. I got it. Okay, thank you.
No, but you're right. So this is the Energy Testing Laboratory of Maine, which we have tried to find if this actually exists still. We haven't found anybody to respond to the questionnaire. And I think this happened the last time we did this review. Is that right, Colleen?
It is, yeah, there was no response the last time either, that the subcommittee looked at it. I mean, if you trace the legislative history, originally this was formed within the Southern Maine Vocational Technical Institute in the 1970s, and there were references to that, and then there were further references later made to Southern Maine Community College. But back in 5 or 6 years ago, those statutory references were removed. So any reference to SMCC having oversight of ETLM were changed as part of sort of a global sort of housekeeping bill that the legislature enacted with regard to the community college system. So we're left with the statute as it's written now, which exempts records essentially maintained by ETLM from FOA. And we think, as Peggy said, we think that this is an entity that's no longer in existence. Can't find any. If you Google it, there's nothing there. We've reached out to the community college system to see if they can track it down. They're not aware that it's still in existence. And so the question is kind of what to do with it. I think last time around, the subcommittee may be faced with the same situation that we just talked about. Didn't want to make a recommendation to repeal the whole thing, and just left it as is.
Wow. In case anyone doesn't know what the acronym is, could you read that?
It's the Energy Testing Lab of Maine.
Okay.
And one of what we think it was formed for the purposes of sort of testing consumer, home appliances, way back when there was those energy usage for various consumer appliances.
Okay.
So
Or at least
dates
that's what they said it's for, right? So this is either a very super secret thing at this point that really needs transparency, or it doesn't exist. So I guess, Linda, what are your thoughts?
So are these records that are now over in archives? I'm sorry, Kate's not here. Maybe she has some idea. But where are these mystery records? Where would they be? Where's the repository for them?
It's classified.
So that's
a
actually
good question. We don't know. Yeah.
We have not asked Kate this question, and maybe we should do that and see if we can find it in the archives. And the other thing,
I wish Kate were here.
Yeah, I know. We should have gotten to her before. Anyway, the other thing that I just thought of was maybe we should talk to the Office of the Budget to see if they have any expenditures or anything that have gone to this lab for any reason, if it received state funding ever. So I think in the past, as Colleen said, when the subcommittee runs into something that they're really not sure what it is, we don't really want to amend it because we don't know what we're doing, because we don't know what it is. So we've skipped over it. What we could do is, if we don't have answers back from archives or the Office of the Budget, we can also put it on the list for next year to try to do an even deeper dive into it.
So one question I have is, what is it that we wouldn't be repealing the authority of this thing to exist, because for the reason before that we talked about a few minutes ago with that other statute, we only have a certain level of a certain degree of a mandate, as John, to use the word John used. So we'd only be acting, I assume, on repealing any kind of provision that says that the records of this thing are confidential. We wouldn't be saying that the whole thing is repealed, right? Is that right?
I think that's consistent with how you've been discussing approaching these types of situations. Yes. Yeah.
Okay. So I'll share my thoughts. I have no problem at all recommending repeal of this protection, if only because now someone can make a FOA request and we'll find out if this lab exists when they say, no, you can't have our records. But I jest a little bit, but I really do think it should be repealed. But I'm just one member of the subcommittee. Anyone have any thoughts? I see no thoughts. Oh, Eric.
Well, I guess my thinking is if we really don't know what it is, if it ain't broke, don't fix it. I would kind of take the opposite view with respect, Chris, that if we really don't know what it is, don't touch it. That'd be my sense.
Oh, yep. No, I totally understand that view. Any other thoughts? Linda?
Well, I guess I would just counter that. What if it's in the public's interest to know what is there? And just to go along with how we proceeded with the marine resources, maybe the path is, and I don't want to lay more work on to Peggy and Colleen, but maybe the thing is to investigate a little bit further and then talk about it next year. I mean, if it's a static entity, it's not going to change, but maybe just more clarity, and then we go through the process.
Yep. That's definitely another approach we could take. So far it's get rid of the protection, keep the protection, study further. Any other thoughts? Do I have any kind of motion? I see no one wanting to make a motion on this. Linda.
So I'm going to make a motion on my thoughts that we would study it further and readdress it next year.
Okay. Do I have a second? Eric? Eric seconds. Is there any discussion? I see none. So why don't we have a roll call? I guess I will. Oh, John, go ahead.
Well, I guess my only question is, do we think there are any avenues that we haven't explored yet that makes kind of putting this on the agenda for next year kind of, likely to produce any different result than what we've got right now in terms of information?
It's a good question. We could submit a FOA request to it and see if they respond, but it doesn't seem like it's going to work.
Well, aren't the avenues like archives and budget?
Seems like that. Yeah. I mean, is that something that I guess I would ask OPLO staff? Is that something we could even try to find out before the next meeting?
Sure. I think so. We could definitely reach out to the archives and see. I don't know how quickly they respond to the request, but we could definitely reach out to Kate and see if they have records.
Yeah. I kind of like that idea as myself, the idea of trying to resolve it this year. But John, you still have your hand up. Did you?
Well, I'll just sort of lay my cards on the table. I mean,
Sure.
I'm uncomfortable repealing a confidentiality provision without knowing what the documents are that would become public, or having some sense of it. I think it's unlikely that there would be any harm to it, but they were obviously made confidential originally for a reason, and, you know, we presume the legislature has good reasons for the things that it does. So I would just, I wouldn't be comfortable voting to repeal it unless I had more information.
Linda.
Just procedurally, if we did find out before next week, when then it would be the whole committee that would vote on, we'd present as a subcommittee to the whole committee for a vote, and then taking care of business relatively quickly, we would hope.
Yeah, it seems like, you know, I guess, you know, maybe the motion would be to move to try to find out some more information between now and next week. And with the idea that the full committee would have some discussion about this and act on it. If that makes sense. John, is your hand still up? Or...
No, I'm sorry. I forgot to put it down.
It's okay. Eric, your hand is up.
Did I hear Colleen or Peggy say that there was some tie-in at some point with the Southern Maine Community College? Did I hear that right? Which would not be a state agency. That's part of the community college system. You know, so anyway, I'm just curious about that. You know, you mentioned the Bureau of the Budget and the state archives, but what about a potential follow-up with somebody at the community college, if I heard that right?
We already have, well, we have been in contact with the community college system, and they have yet to be able to track down any information or provide us with some comments on the questionnaire. We can certainly follow up with them again, given the discussion that you have today. And then if perhaps any records, you know, might be present in the archives, we could also reach out to them and see if there's any previous records. As I mentioned, there was previously a statutory reference to the ETLM being a body within the Southern Maine Community College. And those statutory references were removed, as I mentioned, like 5 or 6 years ago.
Okay. Yeah. Well, I guess I think that approach makes sense. And to John's point, I really appreciated what you said, because even if this lab doesn't exist, it could be that the information, that there are records that exist and that they, you know, would be public in 75 years from their creation, as we know, but they're not. That's not. 75 years has not passed yet. So maybe there was a reason that we wanted them to be confidential. Eric.
Yeah, I just wanted to clarify about the state archives. There's really two parts of the state archives. They have their archives historical collection, which is very small subset of records that are deemed of archival historical value. You know, maybe a portion of 1%, you know, a fraction of 1% of the total volume of records. The great majority, 99% plus, age out after 2 years, 5 years, 10 years, whatever the retention schedule would be, if they even have a retention schedule. And those would not ever convey over to the state archives. It's only where their record center, their warehouse, that is a storage area for, you know, agency records that they want to get out of their office space. And then even those age out. So it's unlikely, in my view, that any of this would be of historical value that would convey ownership to the state archives. It might possibly, they might have a box or two in the warehouse in what they call the Records Management Center. But those are two distinct parts of the state archives. The Record Center for shorter term storage of a volume of records that agencies don't want in their office space. And then the truly archival historical value records, which this is not likely to actually probably be either of those, but it doesn't hurt to ask. But I just wanted the members here to be aware that there's two sides of the Maine State Archives, the historical collection and then the warehouse of shorter term, you know, I say shorter term, maybe 5-10 year storage of records, but aren't of historical value and age out.
No, that's good information to know. It's I always learn something from you, Eric, and from these meetings, and that I did not realize. So I appreciate it. Kevin.
Yeah, I just want to circle back to my original point here a little bit, where I think the focus, if we're going to look for something, is going to be the financial records. The statute, to the extent it's there, there's not much there, but it's exempting them from the Maine Administrative Procedures Act, and it exempts them from public records. So I'm not viewing it as kind of like I said, a confidential provision that's going to at some time be at archives. I'm viewing it as more the legislature intended for this entity, whatever it is, to exist outside of kind of the public records realm. That's kind of how I view it, and I wonder if that's why it is the way it is. So, but certainly I'm curious if there are fiscal records out there, if it says something different than that. But
yeah, that's interesting. I had forgotten that comment was with respect to this exception. So that's an interesting thought about it. Huh. Eric.
Yeah, so if it is in fact financial records, those generally speaking have a lifespan of 5 to 7 years, unless there's something really special that would also be of historical value. But there's a 4-part criteria of records retention. Generally, the guidelines are the immediate administrative use, the day-to-day operational value for the agency, and then there's financial or fiscal or audit value, which generally is 5 to 7 years. And then if there's the third criteria is some specific legal requirement, either legal or regulatory requirement, that's a third criteria. And then the fourth is whether the record has historical or research value. So those 4 criteria. But if, as Kevin's point, if this is really about financial records, and this is an entity that was established in the 70s and maybe went defunct several years ago, the natural life of financial records would age out after 7 years in general principle. And of course, I don't know if they even have a record schedule, but generally speaking, the worldwide standard for financial records is 5 to 7 years, and it's because of the proof of transactions and following the money and auditors and regulators and things like that. But that generally wouldn't have any value or retention need beyond that, generally speaking.
Okay, good. It's good thing to consider. Peggy, did you say that when you said that this had been that this subcommittee at one point had looked at this, how long ago was that? Was that like the first cycle of reviews sort of thing?
Right. You're in your second cycle of review. So 20A, I think we actually spread it out into 5 groups last time, and it's only 4 this time.
So that would have been what,
we're
10,
talking at
10
least
years?
10 years ago.
10 years ago?
Yeah, it was like 2012, I think. Yeah.
Oh, wow. Okay. I mean, I guess I'm thinking about what Linda said earlier, that there might be a public interest that that needs to be addressed here in terms of transparency and access. So I certainly would not want this to be another, 8 years before we have this discussion again, or maybe not us, maybe not me, but someone on this subcommittee. So I guess I myself like the idea of some sort of motion to ask OPLA staff to try to explore this a bit more between now and the next full committee meeting next Wednesday. See if we can maybe act on it as a full committee at that time. But I can't make that motion if anyone even wants it.
Didn't I make the motion?
And I think we had a motion to table to next year. That's on the table. We haven't voted on yet. So,
Oh,
I mean, on the table, meaning you're still discussing it. You haven't disposed of that motion yet.
but you can't discuss tabling motions, I thought. So have we been
Right, I
discussing?
mean, her motion was to move this to next year. I don't think
I
meant
it wasn't to
table.
table.
Yeah,
Gotcha.
move it to next year. Yeah,
I see. Okay. So that motion's on the table, Linda's. Okay, so Linda, go ahead. You're on mute.
Apologize. How about I just amend my motion to to untable it, to study this further and see if we can tend to it by next week. And if not, then use the year to get some more information.
Eric, is that a second? Okay, Eric seconds that. Any discussion? No discussion. Let's, I suppose, have a roll call on it.
Great. Let's roll call in favor of that motion that was just described. We'll start with Kevin Martin. You're up at the top now.
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Linda Clancy,
Yes.
Eric Stout,
Yes.
Chris Parr.
Yes.
So that's 6 members in favor. That's unanimous of those present.
Excellent. Thank you very much.
Yeah, thank you.
The next one numerically, I should say, chronologically, whatever the right term is reference number 61. And this is one that I had a question about. And as I understand it, this makes ballots in elections confidential or non-public. And my the question I had about that was, do they ever, and this maybe is just showing my lack of awareness, do ballots ever become publicly accessible?
They do not.
They do not. Okay. Okay.
There is a procedure in Title 21A where the legislature and certain committees of the legislature or in the governor and the courts can examine ballots, but there is no provision for the public to examine them.
Okay, great. I think I was the one who brought that up and that there were no other questions. So assuming that's the case, I would look for a motion to accept that recommendation, whatever it is, to do nothing.
So moved.
Okay, I have a second. I hear a second, or I hear something.
I'll second.
Okay. Do I have any discussion? No discussion. Why don't we have a roll call?
Great. Those in favor of no change to reference number 61? Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Linda Clancy,
Yes.
Eric Stout,
Yes.
Chris Parr.
Yes. Thank you very much.
That's unanimous.
If it's okay, I'd like to take, there are only 2 reference numbers left, and I'd like to kind of just take them in reverse order and jump to reference number 72. And the question I had, these are regarding, I believe, Commission on Governmental Ethics and Election Practices investigative materials. And I just wasn't clear, and maybe one of you is, as to whether or not those ever become public. I know something becomes public once.
Yeah, I can answer that.
Oh yeah,
Chris.
go, please.
They're my client.
Oh, okay.
So it is a bit of a complicated statute. So the materials that are investigative records become public if there's a standard that's set forth at the end of the section that talks about if they're materially relevant to a determination of the commission. So essentially when the commission does investigations, it gathers, potentially, quite private information from, different entities concerning possible political activities, and whether that information is ever made public, depends upon whether it turns out that it's relevant to the legal issue that the commission is investigating. So, just like any other type of investigation, the commission winds up they issue a subpoena, they wind up getting information that turns out that has very little to do with the issue or is not probative of the issue they're investigating. And that information does stay confidential forever. It's information that they've obtained from a private party. But where it's materially relevant, it can become public through the decisions of the commissioners and the reports submitted by the staff.
Okay, great. That answers that question for me. Thank you. Unless there are any other questions, I would look for a motion to accept the recommendation?
I'll move to accept.
Okay, Julie, I have a second.
I'll second.
Okay, Kevin seconds. Any discussion? No discussion. Let's have a vote.
Great. So this is no changes to reference number 72. Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Fan,
Yes.
Linda Clancy,
Yes.
Eric Stout,
Yes.
Chris Parr.
Yes.
Great. That's 6-0 unanimous of those present.
Excellent. The last reference number is 67. And I had a few questions about this, but it's 252. And I do not want what I think are only my questions about this to require another meeting or what have you. I guess I would maybe be inclined to see if anyone would be interested in tabling this specific reference, the types of records in this, so that the next version of us, or maybe the same version next year, looks at this exception, if we tabled it till next time, if that's possible. And I would ask that of OPLA staff. Is that something that could be done?
Yes, I think so. We have done that in the past.
Okay. And just to give you a sense of my questions, what I was curious about is why are these, is this information only, it's appeared to be only accessible to political parties and persons engaged in political activity. And I just wondered, like, one of my questions was, is the press able to get this information? And then I know that there is the ability to charge fees for the information. And I know that the FOA provision does say something to the effect, I believe, except as otherwise provided by statute, then the fees have to be such and such. And the fees, obviously, from what I could see, are different from what FOA would allow. And I just was kind of curious about that, as to sort of what the policy reasoning was for that. And then and I was happy to see, it looks like this was recently amended so that the misuse of the information, that there can be penalties for that. And I was glad to see that, because this does include what I could see at least some degree of personally identifying information. And another question I had was, how is someone able, what qualifies as a person able to access this information? What do you have to show? What's the vetting process, if any? I'm sure there is one, but what does that look like? But these are all quite, my sort of biggest concern was the penalty aspect in it. And like I said, I was happy to see that it looks like that's been addressed. So I'm more than comfortable, waiting till next year to talk about this, if someone wanted to make that motion. And if no one shares those questions or concerns that I've just said, I'd be totally fine with it not coming up for 8 more years. So however others want to act on it, I'm perfectly happy with. Any discussion? I see no discussion. Oh, Linda.
Well, I appreciate your perspective for the press. And I was reading through it, and it looks like it must have been amended quite a bit over the years. So maybe taking a deeper dive into it is warranted. Next year is an election year, but I don't know if that makes any difference whatsoever. I guess it'll be past election year, so it won't make any difference. But those are my thoughts.
Yeah, and that is correct. It's constantly been evolving since the state went to an electronic system in 2007, I think it is.
Yeah, and I think if I think I was looking, one thing I've learned since I sort of asked these questions, I sent them to John because he represents the agency, is that I think I was looking at the old version, I was possibly, because I don't remember the penalty provisions being in the version that I looked at. It was only after that I saw those. So some of these things, I guess I probably want to look at that some more. Maybe some of my questions were resolved, in addition to that one. Eric.
So I would myself, since it's been thoroughly, vetted by the legislature and recently amended, I would be, comfortable in having confidence in that process. But to defer to Chris's view, to look at it, I would not want to wait 8 years to look at it in the next cycle, but to bring it up next fall when we meet again. But for now, personally, I'm okay with it as it already is, recently changed. But if we're going to look at it again, I would vote to look at it sooner rather than way in the future.
Any other thoughts? Or did I understand? Was that a motion, Eric?
So moved.
I have a second. Julie seconds. All right. Any discussion?
I just have a quick question.
Sure.
Would it be possible to kind of get, I don't know if it's an updated, it's not really an updated kind of chart, but if we could get kind of answers to some of the questions over the course of the year when we review it next year. So if there are questions about certain processes or how it applies, and kind of have those available to us in a year.
Absolutely. We have, I think Chris articulated his questions, and we can definitely follow up both with Jonathan and also directly with the Secretary of State's office. Their contact is very responsive usually to our inquiries. So I don't think that would be any problem to get that information for next time.
Thank you.
Great. That's a good question. John, did you have any thoughts? Not to put you on the spot, whether you're a client agency.
No, I mean, they're my client. Whatever the commission, the committee wants to do is fine.
Okay.
And I'm happy to help out any way I can to, provide information.
Yep. Thank you. Okay, I think we have a motion. I think we have a second. I think we've had discussion, unless there's a desire to have more discussion, which why not? It's 3:00 on a Friday afternoon, but I would look for a roll call.
Okay, so I think the motion is to take this up in next year. Kevin Martin,
Yes.
Jonathan Bolton,
Yes.
Julie Finn,
Yes.
Linda Clancy,
Yes.
Eric Stout,
Yes.
Chris Parr.
Yes.
That's unanimous of the 6 of you. Thank you.
Excellent.
And I
Excellent.
think that's it for all of the exceptions.
I think you're right. We did an exceptional job.
We did.
Now, I'm such a dad, huh? Anyway, the next item is, I think, clarification of some of the confidentiality language recommendation or guidance, I should say. And Peggy, was that you?
Yeah, well, Colleen and I have been working on this, and Rachel too, and we thought it would be useful to have it kind of synthesized down to a shorter summary without so many specifics to go into the report recommendation if you decide to go that way. So we distributed, I think it's 4 paragraphs, and I can share that on my screen if you want.
That'd be great.
Okay. So our thought was that what we really wanted to point out was that the North Star of language is a record is confidential. And then going on from there, you identify when it can be that record's confidentiality doesn't prohibit its sharing with other people. And it's either other people or for other purposes, but you need to be very specific about that. So we were thinking of this as maybe your recommendation as a subcommittee to the whole committee. The subcommittee recommends that the advisory committee adopt as a guiding principle the use of the term confidential when drafting a public records exception. And that the advisory committee does not recommend that statutory language say the record is not a public record. We've had a long discussion of that. And a statute should not cross-reference the Freedom of Access Act generally or Title I, Section 402, subsection 3 specifically. So here's our example. The intake form is confidential. Nice and short. So, and then the underlying principle is that a record that is confidential is not to be disclosed. And maybe we should say to the public there. Or to anybody, actually. But there may be situations where it's necessary to share that information with either particular individuals or entities, particularly when the information was collected for that purpose, to protect somebody's rights in something, to make sure that they're receiving services. When the statute authorizes a disclosure, it should be written clearly and concisely. And we're trying to address the concern that Jim brought up, that some of the language is a little more broad about when you're releasing aggregate information, or you have a record and you're making some of the information in the record public, that you make sure that you're not jeopardizing the confidentiality of anything else in the record that's supposed to be protected. So rather than saying specific language, we're focusing on the standard for determining when it is appropriate for certain confidential information to be released should be stringent. The statutory language should be carefully considered so that if information is released, it would not allow the protected information to be discovered. And we're not sure about this wording. Policymakers should be mindful of emerging technology that permits reverse encryption or other mechanisms to uncover otherwise protected information. I think Eric is our expert, and he's identified that maybe that's not the exact terminology there, reverse encryption. Maybe it's just de-encryption or something else. But, and then also stating that the advisory committee does not expect anybody to take action to go back and change anything that's in the laws right now. This is guidance going forward for new bills and amendments that are being drafted. And when this committee in the future is doing reviews, that maybe they take that opportunity to make the language that they're reviewing consistent at the same time. So trying to avoid saying specifically use this language in all situations with regard to protected information, because we realize that might not work in all situations, and we do want to make sure that we're providing them the best protection. And then Eric can maybe help us figure out exactly what our technology language should be. Is that helpful? I mean, we felt that the discussion at the whole advisory committee meeting last week or the week before, whenever it was, indicated that we needed to be a little more clear in the recommendation.
Yeah, no, that's great.
I'm going to stop there.
Yeah, thank you. Thank you very much, Peggy. Any thoughts, anyone at this point on that? Eric.
So on that last point, the specific kind of that cryptic reference to reverse encryption, I really even didn't know what that meant. I had to research it. that's different than regular encryption and encryption keys, which is a common practice for electronic transactions, secure electronic transactions. That's a different thing. So I recommend that you just strike those words, reverse encryption or other, and just say permits mechanisms and make it more generic. And I think Jim Campbell, who suggested that, would agree with that, making it more general. Okay. Just strike those, those overly specific words. And on the second paragraph, it says that the advisory committee drafts language. Do you really mean that our subcommittee is, maybe you can show that again, is really saying that it's the various other committee, jurisdiction committees and agencies that are drafting language? That second paragraph recommends that the advisory committee adopt a guiding principle when drafting public records exception.
I see.
Are you trying to say it's really, the right to know committee doesn't really primarily have that action, it's others that we're trying to influence them. So maybe consider the wording of that, of who's the action of drafting language, or drafted by,
Right. We expected that to apply to anybody who is drafting them. So what if we say use of the term confidential when public records exceptions are drafted? Right,
but by other people.
By anyone.
Not by the advisory committee.
Right. Yeah, you're right. That was not the best wording.
Yeah. Okay. Just nitpicking that. But other than that, that looks real excellent.
So maybe if it said something like the subcommittee recommends that the guiding principle be adopted of the use of the term confidential when public records exceptions are drafted by those drafting legislation, or something like this. I'm sure, Peggy, you have a much better way of saying what Eric is trying to say than I just tried. So.
Yeah. I think that was the intent. It's just kind of nitpicking about who has the action there. It's not us, but it's everybody else that's drafting the language.
That's a good point, Eric. It's not so much I guess it's more of a comment, but it's sort of almost a rhetorical question, because I'm not sure if there's an easy answer. But I think your point, Peggy, in that paragraph about the underlying principle that is that a record that is confidential is not to be disclosed, but it seems like publicly doesn't. Does that mean publicly, but then you get into what is public, what does publicly mean, because does that mean that you can share it with a specific person, but not generally with the public, but I don't know what the solution is there. I think it's the sort of thing where almost common sense has to have some role in this, in terms of what the intent is. The only thing I could think of is not to be disclosed for unofficial purposes, or for purposes not authorized, not consistent with law, but I don't know. I don't know that even necessarily has to be said, but so that's why I'm thinking it's more of just a thought, but I don't really have a solution.
Well, we're trying to put this together for you as the subcommittee. So, not to put it back on you so much as we want to make sure that the wording is an accurate reflection of what you want to happen. So if we need to kind of work on that a little bit, we can.
Yeah, I don't know. Go ahead.
Oh, I was just going to say, we're trying to draw the distinction between what was kind of this informal interpretation of when you say something is not a public record, that meant the public record custodian could share it, but the public didn't necessarily have a right to it. And we're trying to use the same terminology in all situations, not call something not a public record, and make it clear that confidential means it is not shared, it's not disclosed. That if it's going to be shared with law enforcement, then you say, except that it may be disclosed to law enforcement. for.
So make it like the custodian or the person or the agency. It's not, is it understood it's not to be disclosed outside that agency that maintains the record? So if that's understood, if that's the given, then maybe it should be is not to be disclosed except as expressly authorized or allowed, permitted by law. Is that what you were just kind of saying? If that's how kind of the standardization is going to be going forward, then maybe that's what should be said. Is not to be disclosed maybe by the agency or maintaining or from which the record originates, except as expressly authorized by law. But that might be even too much wording. But I do think if this is a going forward standard, I like the idea of except as expressly authorized by law. So anyone? Oh, Eric, your hand up.
Yeah, I hesitate to bring this up again because it's my favorite song to sing, and I don't want to take too much time because we're over time. But the Federal Privacy Act of 1974, as amended, takes this whole approach of every record that is covered under the Privacy Act requires a Privacy Act notice on the collection form, and a Privacy Act system of records notice that describes the specific purposes for which this information is collected. It's collected for this specific governmental function, and the exceptions of how it may be released are typically commonly for law enforcement or under a court order or, under specific circumstances. So we don't take that approach here in Maine. We don't say this is confidential except for these 7 reasons, but there's like 7 or 8 or maybe 9 common reasons under the Federal Privacy Act that things are kept private and protected under the Privacy Act, and those penalties for release, except explicit things that are explicitly stated in the Privacy Act statement and in the system of records notice. But we don't take that approach here, but maybe in general terms, like except as expressly authorized by law would be a general way to cover that. But I just wanted to kind of put that out on the table for the awareness of the group here, that's how the Federal Privacy Act is, expressed for each type of record that is covered under the Privacy Act. They have explicit exclusions that have to be published. But maybe this that Peggy just put in there is good enough for how we do it here in Maine.
Yeah, no, I am in agreement with the idea of a Privacy Act at some point, hopefully soon for this state. But I think for now we work with what we have. But I think that's a goal to strive for. I guess one question is what I wouldn't want that language to make to cause confusion about is that if we say except as expressly authorized by law, should we also say or by court order? Just because court orders sometimes are the way that things that are otherwise confidential might have to be produced. And I think that's important to ensure that courts have the ability to disclose information if it's in the public interest through a court order. So.
Well, and just remember, this is kind of a narrative
right.
of the policy. You're not actually writing this into statute right now.
Okay. Yeah, no, that's good. Okay. Is there anything about what's on the screen, or are we ready to have that taken down? So raise your electronic hand because I can't see everyone. I don't see. Okay, I think we're good. Thank you, Peggy. So unless there's further discussion, I guess I would entertain some sort of motion. I guess it would be to accept what we just looked at. I mean, does this require a motion? Or is this the sort of thing that you think we need a motion, or can we just kind of say we're good with it?
You can, I guess if it's a recommendation of the subcommittee, then you probably need to vote.
Yeah, I think you're probably right. Eric?
So moved.
Okay, so as I understand Eric's motion, it's to accept the guidance that we were just looking at as amended in real time per our discussion. Do I have a second?
Second.
Okay, Kevin seconds, Linda seconds too. Any discussion? No discussion. Well, let's have a vote.
All right, the vote is on the motion to accept the guidance as we have just changed it. Roll call for Kevin Martin,
Yes.
Linda Clancy,
Yes.
Eric Stout,
Yes.
Chris Parr,
Yes.
Julie Finn,
Yes.
and did John have to leave?
He did.
Yes.
Yep.
Okay. So that is 5 in favor, unanimous of those present.
Excellent. I think that's everything there, except for, I think then if I'm going by memory now, so I think it was anything new. So I would ask under this item, if Rachel has anything that she wants to say, because she's been here, or,
No, I'm all set. I took some very diligent notes.
all right, excellent. And where Brenda has been here as well, I'd invite her to comment on anything public records exception or right to know in general that she would want to comment on.
Thank you, Chris. You did a really thorough job today. I don't have anything to add to your discussion.
All right, excellent. So I think we were at that point, unless there are any other topics that anyone wants to raise so that we can have a meeting on Saturday morning. Kidding. I think our work is concluded for this year, for this term. So I would entertain a motion to adjourn. And I would thank you all first before we do that for all your hard work and time and putting up with me. So I appreciate it. Do I have a motion?
I think we should thank Chris for serving as chair also.
Well, thank you. I know it was Julie's idea, so.
And a good one.
It was my honor. So, all right. Do I have a motion to adjourn?
So moved.
All right. Do I have a second?
Sure.
All right. All those in favor? By a show of hands. All right. Looks like we are unanimous. Thank you so much. Have a great weekend.
Thank you, everybody. We'll
Take
get
care.
a report out to you quick.
Yes,
You
thank you
too.
all.
Thanks.